Like almost all federal cases, this one started in district court. This case began in the United States District Court for the Southern District of California in 2023, when two teachers sued seeking an exemption from their school district's policy regarding students' gender. During litigation, the school district claimed that state law, as interpreted by the California Attorney General and Department of Education, required it to adopt these policies. So the teachers added state officials as defendants, and parents of California's school children joined the lawsuit as plaintiffs. This case didn't start with the parents, but with two teachers. Parents joined the suit later. At first, things seemed to go well for the parents and teachers. After discovery, the court granted summary judgment for all plaintiffs and entered a permanent injunction in their favor. The injunction prevented the schools from misleading parents about their children's gender presentation at school and their social transitioning efforts. It also requires the school to follow parents' direction regarding their children's names and pronouns, and it compels defendants to include in state-created or approved instructional materials a notice of the rights protected by the injunction. Big win for the parents. Schools were enjoined from misleading parents about their children's gender presentation and required schools to follow parents' instructions about names and pronouns. It even required the state to include notices of the protection in the instruction material. Then the Ninth Circuit stepped in to slow down the process. The Ninth Circuit granted the defendant's motion to stay the injunction pending appeal. It began by raising procedural objections to the district court's injunction. It claimed that the district court had granted class certification without undertaking the rigorous analysis required by federal rules of procedure. And it stated that the injunction appeared to be overly broad because it covers every parent of California's millions of public school students and every public school employee in the state. As a result, it opined, the injunction seemed to grant relief to uninjured class members who lacked Article III standing. Notice, the Ninth Circuit didn't say that they thought the defendants had a chance of winning, only that they had technical issues with how the district court went about the case.